CPLR Article 31. 3101 Disclosure. There shall be full disclosure of matter material necessary in the prosecution or defense. Shall not be disclosed or obtained: 1. Privileged matter. 2. Attorney's work product. 3. Trial preparation. Those three things shall not be disclosed: privileged matter, attorney's work product, trial preparation. 3102. Disclosure devices. 1. Depositions upon oral questions, or without the state upon written questions. 2. Interrogatories. 3. Demand for addresses. 4. Discovery and inspection of documents or property. 5. Physical and mental examinations of persons. 6. Requests for admissions. One more time real quick. Disclosure devices. 1. Depositions. Oral questions or without the state, written questions. Interrogatories. Demand for addresses. Discovery and inspection of documents of property. Physical and mental examinations of persons. Request for admission. And disclosure before an action is commenced must be done by a court order, and after the action is commenced or during trial, disclosure may be obtained only by order of the trial court on notice to the other side. So before the action is commenced, you need a court order for disclosure. And after the action is commenced or during the trial, it can be obtained only by order of the trial court on notice to the other side. 3103, protective orders. The court may at any time, on its own motion or on motion of any party or of any party from discovery sort, make a protective order, either denying, limiting, conditioning, or regulating the use of any disclosure device. So the protective order can be on motion of the court or motion of any party or any party from discovery sort, and the protective order can deny, limit, condition, or regulate the use of any disclosure device. 3104. Upon motion of any party or witness on notice to all the parties, or upon the court's own motion without notice, the court, by one of its judges or referees, supervise all or part of any disclosure procedure. A referee shall have all the powers of the court except: 1. The power to relieve himself of duties. 2. To appoint a successor. And 3. To adjudge someone guilty of contempt. So a referee can do anything that a judge can do, except he can't relieve himself, he can't appoint somebody else to do it, and he can't hold somebody in contempt. Any party or witness may make a motion to review an order of a referee. Motion shall be made within 5 days after the order is made. Review for a referee order equals 5 days. 3105. When a party is in default for failure to appear, he shall not be entitled to notice or service of any copy required under this article. 3106. Any party may take the testimony of any person by deposition upon oral or written questions. Where the person to be examined is not a party, or the person is an officer, director, or member of the employee of the party, he shall be served with a subpoena, and the subpoena shall be served at least 20 days before the examination. So if you want to examine somebody who's not a party, or if the person is an officer, director, or member of, or employee of the party, you have to subpoena them, and the subpoena has to be on at least 20 days notice before the examination. 3107. A party desiring to take the deposition of any person upon oral examination shall give each party 20 days notice stating the time and the place. But if the person to be examined is a party, you only have to give them 10 days notice. 3114, if the witness to be examined does not understand English, the examining party must, at his own expense, provide a translator. 3116, the party taking the deposition shall bear the expense. 3117, any deposition may be used by any party for the purpose of contradicting or impeaching the testimony of the defendant. 3121, notice of examination. After commencement of an action in which the mental, physical conditions of a party or agent, employee, or person in custody of legal control of the party is in controversy, any party may serve notice to the other party to submit to a physical, mental, or blood examination. And a copy of the notice shall be served on the person to be examined, and the notice shall specify 1. The time and place, not less than 20 days after the notice is served, and 2. Any conditions and the scope of the examination. So, the notice of examination. That examination cannot be earlier than 20 days after the notice of examination is served. So you got to give them 20 days notice, and it also has to be served on the person to be examined and his attorney. 3122, if a party or person objects to the disclosure, inspection, or examination, he shall serve a response which shall state with reasonable particularity the reasons for each objection within 20 days of notice of subpoena ducis tecum. So if somebody is served with a subpoena ducis tecum and he objects, he has to serve a response that he objects with his reasonable particularities, and he has to do that within 20 days. 3122, business records. Business records produced pursuant to a subpoena ducis tecum shall be accompanied by a certificate sworn in the form of an affidavit and subscribed by the custodian or other qualified witness charged with the responsibility of maintaining the records. And that certificate/affidavit shall state 1, that the affiant is the duly authorized custodian and has the authority to make the certification, and 2, to the best of the affiant's knowledge, the records copies are accurate versions of the documents in the subpoena ducis tecum, and 3, to the best of the affiant's knowledge, the records copies represents all the documents in the subpoenas ducis tecum, and 4, that the records or copies were produced by the personnel or staff of the business. So a subpoenas ducis tecum for business records, the person supplying those business records has to supply that certificate/affidavit stating those 4 things. And if a party intending to offer a trial or hearing business records, they shall give notice of such intent and specify the place where such records may be inspected at least 30 days before the trial or hearing. If the other side objects to those business records being used, then he makes that objection. Like I'm touching the ceiling. When I'm with you, I can't breathe. Boy, you do something to me. CPLR Article 3201. No judgment by confession shall be entered on any affidavit which was executed prior to the time of default in payment of an installment, and it occurs in connection with the purchase of $1,500 or less of any commodities. Any judgment entered in violation of this section shall be void and unenforceable. 3211, motion to dismiss. Motion to dismiss cause of action. A party may move for a judgment dismissing one or more causes of action asserted against him on the grounds that 1. A defense is founded upon documentary evidence. Or 2, the court has not jurisdiction of the subject matter of the cause of action. Or 3, the party asserting the cause of action has not legal capacity to sue. Or 4, another action pending between the same parties for the same cause of action in a court of any state. Or 5, cause of action may not be maintained because of arbitration and award, collateral estoppel, discharge in bankruptcy, infancy or other disability of the moving party, payment, release, res judicata, statute of limitations, or statute of frauds. Or 6, with respect to a counterclaim, it may not properly be interposed in the action. Or 7, the pleading fails to state a cause of action. Or 8, the court has not jurisdiction of the person of the defendant. Or 9, the court has not jurisdiction in an action where service was made under Section 314, service without the state, or 315, service by publication. Or 10, the court should not proceed in the absence of a person who should be a party. And 11, the party is immune from liability. Motion to dismiss a defense, though. A party may move for a judgment dismissing one or more defenses on the ground that a defense is not stated and has no merit. And service of a notice of motion to dismiss before serving a pleading responsive to the course of action or defense extends the time to serve the pleading until 10 days after service of the notice of entry of the order. So notice of motion, you get 10 days after the entry of the order to serve your pleading. 3212, motion for summary judgment. Any party may move for summary judgment in any action after the issue has been joined, provided, however, the court may set a date after which no such motion may be made, the date being no earlier than 30 days after the filing of the note of issue. If no date is set by the court, such motion shall be made no later than 120 days after the filing of the note of issue, except with leave of court or for good cause shown. So the note of issue gets filed, and the date that the court sets can't be earlier than 30 days after that filing. So the note of issue is filed, and the date not earlier than 30 days after it's filed. You cannot file your motion anymore after that. One more time, the note of issue gets filed. The court can set a date, but it can't be earlier than 30 days after they file that note of issue. So let's say the note of issue gets filed on the 1st. The court can set that date for the 30th. And then after that, you cannot file a motion for summary judgment. And if the court doesn't set a date, then the motion for summary judgment shall be made no later than 120 days after filing the note of issue. So the note of issue gets filed, you have 120 days to file that motion for summary judgment. A motion for summary judgment shall be supported by 3 things. 1, an affidavit. 2, a copy of the pleadings. And 3, other available proof, depositions, and written admissions. And that affidavit that the motion for summary judgment shall be supported by, that affidavit shall 1, be by a person having knowledge of the facts. 2, shall recite all the material facts. And 3, show that there is no defense to the cause of action or that the cause of action or defense has no merit. In matrimonial actions, summary judgments may not be granted in favor of the non-moving party. In any other action, summary judgments may be granted in favor of any one or more parties. The court may also direct 1, that the cause of action to which the summary judgment is granted shall be severed from any remaining cause of action, and 2, that the entry of the judgment shall be held in abeyance pending the determination of any remaining cause of action. If motion for summary judgment is denied or granted in part, the court shall, if practicable, ascertain what facts are not in dispute or are incontrovertible. It shall thereupon make an order specifying such facts, and they shall be deemed established for all purposes in the action. 3213. When an action is based upon payment of money only or upon any judgment, the plaintiff may serve the summons with the notice of motion for summary judgment and supporting papers in lieu of the complaint. The summons served with the notice of motion for summary judgment shall require the defendant to submit answering papers on the motion within the time provided in the notice of motion. Remember, notice of motion papers are 820-1671. Unless you want to file cross motions, then your cross motion would be 830-1671. And if you're mailing them, you add 3, and overnight you add 1. The minimum time such motion shall be noticed to be heard shall be the same as the time for making an appearance, which would be 20 days or 30 days. And if the plaintiff sets the hearing date of the motion later than the minimum time, he may require the defendant to serve a copy of his answering papers upon him within such extended time period, not exceeding 10 days prior to such hearing date. And no default judgment may be entered prior to the hearing date of the motion. If the motion is denied, the moving and answering papers shall be deemed the complaint and answer. 3214, Judge supervising disclosure. Unless the chief administrator of the courts has by rule provided otherwise, if a case has been assigned to a judge to supervise disclosure, all motions preliminary to trial shall be referred to such judge whenever practicable. Stay of disclosure, service of a notice of motion under Rule 3211, a motion to dismiss, 3212, a motion for summary judgment, 3213, a motion for summary judgment in lieu of the complaint, stays disclosure until determination of motion unless the court otherwise orders otherwise. But if the motion is based solely on the defense that the summons and complaint, the summons with notice, or the notice of petition, CPLR Article 34. 3401. The Chief Administrator shall adopt rules regulating the hearing of cases. 3402. Notes of issue. Places a case on the calendar. 1. At any time after issue is joined. Or 2. At least 40 days after service of summons has been completed. A defendant or plaintiff can file the note of issue. The procedure is you serve the note of issue on the other party, then file 2 copies of the note of issue and proof of service with the clerk of the court within 10 days of service. The clerk shall enter the case upon the calendar as of the date of filing the note of issue, and a party bringing in a new party shall, within 5 days, serve him with the note of issue. 3403, trial preferences. Civil cases shall be tried in the order in which the notes of issue are filed, but the following shall be entitled to preference. 1. An action brought or against the state. 2. An action where a preference is provided by the statute. 3. An action in which the interest of justice will be served by an earlier trial. 4. An action upon application of a party 70 years old or older. 5. An action to recover damages for medical, dental, or podiatric malpractice. 6. An action to recover damages for personal injuries where the plaintiff is terminally ill as a result of the negligence of the defendant. So the preferences, once more, are the state, the statute, interest of justice, application of 70-year-old, recover damages in med mal, recover damages in personal injury where the plaintiff is terminally ill. Notice of a motion for preference shall be served with the note of issue by the party serving the note of issue or 10 days after such service by any other party. 3404, dismissal of abandoned cases. A case in Supreme or County Court marked off or struck from the calendar or unanswered and not restored within 1 year shall be deemed abandoned and shall be dismissed without cost for neglect to prosecute. The clerk shall make an appropriate entry without the necessity of an order. 3406, mandatory filing and pre-calendar conference in medical, dental, and podiatric malpractice actions. 1. Mandatory filing. The plaintiff shall file a notice of medical, dental, or podiatric malpractice not more than 60 days after issue is joined. After the defendant answers, he has to file that notice of medical, dental, or podiatric malpractice not more than 60 days after the issue is joined. And the plaintiff shall file the notice of medical, dental, and podiatric malpractice and proof of service upon all parties, and proof, if demanded, authorization to obtain medical records have been served upon the defendant, and other papers as may be required to be filed by rule of the Chief Administrator. Time for filing notice of medical, dental, and podiatric malpractice may be extended by the court upon motion pursuant to Article 2004, extensions generally. Pre-calendar conference is also required in medical, dental, and podiatric malpractice after issues joined, but before the note of issue is filed, the purpose of which shall include 1. Encouraging settlement, 2. Simplifying or limiting issues, 3. Establishing a timetable for disclosure, 4. Establishing a timetable for offers, depositions, future conferences, and trial. The timetable for disclosure shall be completed within 12 months after the notice of medical, dental, and podiatric malpractice has been filed, not later, and shall require all parties to be ready for trial no later than 18 months after such notice is filed. So, in medical malpractice actions, 4 things. Notice of med, dental, and podiatric has to be filed within 60 days after the issue is joined. Requires a pre-calendar conference. Disclosure must be complete within 12 months, and both sides must be ready for trial within 18 months. 3407, terminally ill parties. At any time, a party who is terminally ill, who asserts that such illness is the result of the other party, may request an expedited preliminary conference. Such requests shall be filed in writing and shall be accompanied by a physician's affidavit. The court shall hold a preliminary conference within 20 days of filing such request. The preliminary conference, the court shall issue an order, 1, establishing a schedule for the completion of discovery to be completed within 90 days of the preliminary conference. 2, that the note of issue and a certificate of readiness be filed within the period of time specified in the order. And 3, that the action receive a trial preference to be commenced within 1 year from the date of such order. So, preliminary conference, the court's order shall, 1, establish the time for discovery that has to be completed within 90 days from the preliminary conference, and that the note of issue and the certificate of readiness be filed, and that the action receive a trial preference and has to be commenced within 1 year of the date of the order.
Baby, lay on back and relax. Kick your pretty feet up on my dash. door right here. How many ways can I say that I need you, baby? It's true. I think I might die without you.
CPLR Article 41. 4101. In the following actions, an action which would permit a judgment for the sum of money only, an action of ejectment for dower, for waste, for abatement of and damages for a nuisance, to recover chattel, for a determination of the claim to real property, and any other action in which a party is entitled by the Constitution or by express provisions of law to a trial by jury. The issues of fact shall be tried by a jury unless a jury trial is waived or reference is directed, except that in equitable defenses and equitable counterclaims shall be tried by a court. 4102. Demand and waiver of trial by jury. Any party may demand a trial by jury and any issue of fact triable of right by jury by serving upon all parties and filing a note of issue containing a demand for a jury trial. Any party served with a note of issue not containing such demand for a jury trial may demand a trial by jury by serving upon each party a demand for a trial by jury by filing such demand in the office where the note of issue is filed within 15 days after service of the note of issue. So if somebody serves you a note of issue that doesn't contain a demand for a trial jury and you want a trial jury, you can do that within 15 days after service of the note of issue. A demand for a trial by jury shall not be accepted unless a note of issue is filed in the action. If no party shall demand a trial by jury, the right of the trial shall be deemed waived by all parties. A party may not withdraw a demand for a trial by jury without consent of the other parties, regardless of whether another party previously filed a note of issue without a demand for the trial by jury. So, if you want a trial by jury and you are the one filing the note of issue, then you have to include your demand for a jury trial with your note of issue. On the other hand, if you are the one who is being served with a note of issue and it does not contain a demand for a jury trial, but you want one, then you must file your demand within 15 days of being served with that note of issue, which did not have the demand for the jury trial. In his demand, a party may specify the issues which he wishes tried by a jury. Otherwise, he shall be deemed to have demanded trial by jury of all issues. If he has demanded trial by jury of only some of the issues in his demand, any other party within 10 days after service of the demand serve and file a demand for a trial by jury of any other issues. 4104. A jury shall be composed of 6 persons. 4105. The first 6 persons who appear as their names are drawn and called and are proved as indifferent between the parties and are not discharged or excused must be sworn in and constitute the jury to try the issue, the first 6 that both sides agree to form the jury. 4106. One or more additional jurors, alternate jurors, may be drawn upon the request of a party. Such jurors shall be drawn at the same time, from the same source, in the same manner, and have the same qualifications as regular jurors. They shall be seated with, take the oath with, and be treated in the same manner as the regular jurors, except that, after final submission of a case, the court shall discharge the alternate jurors. If, before final submission of the case, a regular juror dies or becomes ill, the court may order him to be discharged and draw the name of an alternate who shall replace the discharged juror in the jury box. 4107. Upon application of any party, a judge shall be present at the examination of the jurors, so the judge does not have to be present at the examination of the jurors, only on application of any party. 4108. An objection to the qualifications of a juror must be made by a challenge unless the parties stipulate to excuse him. 4109. Peremptory challenges. No explanation needed if you don't like the juror. That's what a peremptory challenge is. You don't have to give a reason. The plaintiff shall have a combined total of 3 peremptory challenge plus 1 peremptory challenge for every 2 alternates. The defendant, other than a third-party defendant, shall have a combined total of 3 peremptory challenges plus 1 peremptory challenge for every 2 alternates. So each side gets 3 peremptory challenges. The court, in its discretion, before the examination of jurors begins, may grant an equal number of additional challenges to both sides. 4110. Challenges for cause. That's when you have to show cause why you don't want that juror, and that's unlimited. The fact that the juror is employed by a party, or if the party is a corporation, if the juror is a shareholder or stockholder, or if an action for damages for injuries to a person's property if he is a director, officer, employer, or in any manner interested in any insurance company issuing policies for liability, shall constitute grounds for a challenge for cause. The fact that the juror is a resident or liable to pay taxes in the city, village, town, or county who is a party to the action shall not be grounds for a challenge for cause. Also, persons shall be disqualified as jurors if related within 6 degrees of consanguinity or affinity to a party. The party related to the juror must raise his objection before the case is opened. Any other party must raise the objection no later than 6 months after the verdict. 4110B. Instructions to jury. Objection. At the close of the evidence or earlier during the trial, pre-charge conference, any party may file a written request that the court instruct the jury of the law. Outside of the hearing of the jury, the court shall inform counsel of its proposed action upon the request, prior to their arguments to the jury. But the court shall instruct the jury after the arguments are completed. If counsel objects to anything the judge is going to instruct the jury, they must object beforehand. Otherwise, they are not going to be able to bring that issue up on appeal. 4110C. Viewing the premises. During the course of a trial, the court may, in its discretion, at any time before the commencement of summations, order that the jury view the premises. In such case, 1. The jury must be kept together throughout. 2. The court must be present throughout. 3. The parties and counsel may be present as a matter of right. 4. Neither the court, the parties, counsel, or the jurors may engage in discussion concerning any issue of the case, and it's solely to permit visual observation by the jury of the premises. 4111. General and special verdicts. The court may direct the jury to find either a general or special verdict. A general verdict is a verdict which the jury finds in favor of one or more parties, and the jury makes the decision.
Head over heels in love, right in front of you, ain't gotta look no more, baby. I wanna build this love, and everything you own, you ain't gotta ask for, you got.
CPLR Article 44. 4401. Motion for judgment during trial. Any party may move for a judgment with respect to a cause of action or issue upon the grounds that the moving party is entitled to judgment as a matter of law. After the close of the evidence presented by the opposing party with respect to such cause of action or issue, or at any time on the basis of admissions. Grounds for the motion shall be specified, and the motion does not waive the right to trial by jury or to present further evidence, even where it is made by all parties. 4401, motion for judgment. A motion for judgment at the end of the plaintiff's case must be granted as to any cause of action for medical malpractice based solely on lack of informed consent if the plaintiff has failed to adduce expert medical testimony in support of the alleged qualitative insufficiency of the consent. 4402, motion for continuance or new trial during trial. At any time during the trial, the court on motion of any party may order a continuance or a new trial in the interest of justice on such terms as may be just. 4403, motion for new trial or to confirm or reject or grant other relief after reference to report or verdict of advisory jury. Upon the motion of any party or on his own initiative, the judge required to decide the issue may confirm or reject in whole or in part the verdict of an advisory jury or the report of a referee to report, may make a new finding with or without taking additional testimony, and may order a new trial or a hearing. The motion shall be made within 15 days after the verdict or the filing of the report and prior to further trial in the action. Where no issue remains to be raised, the court shall render decision directing judgment in the action. 4404, post-trial motion for judgment and new trial. Motion after trial where the jury is required after a trial of a cause of action or issue triable of right by a jury. Upon the motion of any party or on its own initiative, the court may set aside the verdict or any judgment entered thereon and direct the judgment be entered in favor of a party entitled to judgment as a matter of law, or it may order a new trial of cause of action or separate issue where the verdict is contrary to the weight of the evidence in the interest of justice, or where the jury cannot agree after being kept together for as long as is deemed reasonable by the court. Motion after trial where jury is not required, after a trial not triable by the right of a jury. Upon the motion of any party or on its own initiative, the court may set aside its decision or any judgment entered thereon. It may make new findings of fact or conclusions of law, with or without taking additional testimony, render a new decision and direct entry of judgment, or it may order a new trial of a cause of action or a separate issue. 4405, time and judge before whom post-trial motion be made. A motion under this article shall be made before the judge who presided at the trial within 15 days after decision, verdict, or discharge of the jury. The court shall have no power to grant relief after argument or submission of an appeal from the final judgment. 4406, single post-trial motion. In addition to motions made orally immediately after decisions, verdict, or discharge of the jury, there shall be only one motion under this article with respect to any decision by a court, or to a verdict on issues triable of the right by a jury, and each party shall raise by the motion or by demand under Rule 2215 every ground for post-trial relief then available to him. CPLR Article 5001. Interest shall be computed from the earliest ascertainable date the cause of action existed, the amount of interest shall be computed by the clerk of the court. 5002, the amount of interest shall be computed by the clerk of the court and included in the judgment. 5003, every money judgment shall bear interest from the date of its entry. 5003, prompt payment following settlement if both sides settle. Any settling defendant, except a municipality or the state, shall pay all sums due to any settling plaintiff within 21 days of tender by the settling plaintiff a duly executed release of a stipulation of discontinuance. If the settling defendant is a municipality, shall pay all sums due to the settling plaintiff within 90 days of tender by the settling plaintiff a duly executed release and a stipulation of discontinuance. If the settling defendant is the state, shall pay all sums to any settling plaintiff within 90 days of the comptroller's determination that all papers required to effectuate settlement have been received by him. So if there's a settlement, normally the defendant has to pay the plaintiff within 21 days. But if it's a municipality, he has to pay within 90 days. And if it's the state, he has to pay within 90 days of the controller's determination that all the papers required to effectuate settlement have been received by him. 5004, interest shall be at the rate of 9% per annum. 5011, a judgment is the determination of the rights of the parties in an action or a special proceeding and may be final or interlocutory. 5013, a judgment dismissing a cause of action before the close of the proponent's evidence is not a dismissal on the merits, but a judgment dismissing a cause of action after the close of proponent's evidence is a dismissal on the merits. So, if the case is dismissed halfway through the case for a technicality or some other reason, and the plaintiff is not done presenting all of his evidence, he can start over again and file because the dismissal is not on the merits. But if after the plaintiff has presented all of the evidence and the case is dismissed, that would be a dismissal on the merits. 5014, except as permitted in 15102 of the GOL, an action upon a money judgment entered in court of the state may only be maintained between the original parties to the judgment where 1. 10 years have elapsed since the first docketing of the judgment. An action may be commenced during the year prior to the expiration of 10 years since the first docketing of the judgment. The judgment in such action shall be designated a renewal judgment and shall be so docketed by the clerk. Or 2, the judgment was entered against the defendant by default for want of appearance, and the summons was served other than by personal delivery. And 3, the court so orders a motion with such notice to such other persons as the court may direct. 5016, a judgment is entered when, after it has been signed by the clerk, it is filed by the clerk. Judgment upon a general verdict of a jury after a trial by jury shall be entered by the clerk of the court unless court otherwise directs. A special verdict, the court shall direct entry of an appropriate judgment. A decision of the court or referee shall be entered by the clerk of the court. No verdict or decision shall be rendered against a deceased party, but if the party dies before the entry of judgment and after a verdict or decision, judgment shall be entered in the name of the original parties. To sum up 5016, a judgment is entered when it has been signed by the clerk and then filed by him, and a judgment upon a general verdict shall be entered by the clerk of the court, and a special verdict, the court shall direct the entry of an appropriate judgment, and a decision of the court or the referee shall be entered by the clerk of the court, and no verdict or decision shall be rendered against the deceased party, but if the party dies before the entry of judgment, but after the verdict, judgment shall be entered in the names of the original parties. 5017, judgment roll. A judgment roll shall be prepared by either the attorney for the party whose instance the judgment is entered, or by the clerk of the court. It shall be filed by the clerk when he enters judgment, and shall state the date and time of its filing. The judgment roll shall contain SPAJO, S-P-A-J-O, summons, pleadings, admissions, each judgment, each order involving the merits or affecting the final judgment. 5020, when a judgment creditor receives satisfaction or partial satisfaction of a judgment, he shall execute and file with the clerk a satisfaction piece within 20 days of payment. A copy of the satisfaction, partial satisfaction piece filed with the clerk shall be mailed to the debtor by the creditor within 10 days after filing satisfaction. When a judgment is fully satisfied, the creditor is required to file a satisfaction within 20 days after receiving full satisfaction. If he does not file the satisfaction within 20 days of receiving payment, the judgment creditor shall be subject to a penalty of $100, and within 10 days of that filing, the creditor has to mail satisfaction to the judgment debtor. So, satisfaction equals 20/10. 20 days to file the satisfaction after payment, 10 days to mail to the debtor after filing the satisfaction.
I think that I'm done tripping, I'm tripping, I've been sipping, that's how I control this feeling. You keep giving, you keep on hitting it, ooh,
CPLR test number 5. Number 1, at any time after issue is first joined, or at least 40 days after service of the summons has been completed, irrespective of joinder, any party may place a case upon the calendar by filing, within 10 days after service, with proof of such service, 2 copies of a note of issue with the clerk. So that's any time after issue is first joined, or at least 40 days after service of the summons is complete. 2, 3403. The following are entitled to a trial preference. 1, in an action where the party is 70 years old. 2, in an action to recover damages from medical malpractice, medical, dental, or podiatric malpractice. 3, in an action to recover damages for personal injury, where the plaintiff is terminally ill and alleges that the illness is the result of the conduct of the negligence of the defendant. Also, an action brought or by the state. Also, an action where the statute for preference. Also, interest of justice will be served. 3, 3403B, in general, if a note of issue is filed without a request for preference, any other party in the action entitled to a preference should make that motion for preference within 10 days of the filing of the note of issue. 4, 3404. A case in the Superior Court marked off or struck from the calendar or unanswered on the clerk's calendar call and not restored within 1 year thereafter shall be deemed abandoned and shall be dismissed without costs for neglect to prosecute. The clerk shall make an appropriate entry without the necessity of an order. 5, 3406. Not more than 60 days after issue is joined, The plaintiff in an action for dental, medical, or podiatric malpractice shall file with the clerk of the court which the action is commenced a notice of dental, medical, or podiatric malpractice. 63407, a party who is terminally ill files a request for an expedited preliminary conference. The court shall hold such conference within 20 days of filing the request. What defenses can be raised at any time? 1, subject matter jurisdiction. 2, non-joinder. And 3, failure to state a cause of action. 74104, a civil jury shall consist of how many persons? 6. 84106, unless the court orders otherwise, the number of alternate jurors in a civil case should be 1 or more. 104110, a party may challenge how many jurors for cause? Unlimited. 114113, a civil jury may reach a verdict only if how many agree? 5 out of 6. 124110, civil trials. 1, request to instruct the jury may be made at the close of the evidence or at such earlier time as the court reasonably directs. 2, the court outside the presence of the jury shall inform counsel of its proposed action on the request prior to their closing arguments. 3, the court's instructions to the jury must be given after closing arguments are completed. And 4, such requests are limited to instructions on the law. 154102, any person served with a note of issue not containing a jury demand may make a jury demand by serving upon all other parties and filing a jury demand within 15 days after service of the note of issue that didn't have a jury demand. 143211, affirmative defenses are waived if not raised in a motion to dismiss. Those affirmative defenses are 1, a defense founded upon documentary evidence. 2, the party asserting the cause of action has no legal capacity to sue. 3, the cause of action may not be maintained because of arbitration and award, collateral estoppel, discharge in bankruptcy, infancy or other disabilities of the moving party, release, res judicata, statute of limitations, or statute of frauds. 4, with respect to a counterclaim, it may not be properly interposed in the action. 5, the pleadings fail to state a cause of action. 6, the court has not jurisdiction of the subject matter. 7, the court has not jurisdiction of the person, the defendant. 8, the court has not jurisdiction where service was made under 314 or 315 and that service without the state and publication. 9, the court should not proceed in the absence of a person who should be a party. 10, party is immune from liability. And 11, there is another action pending between the same parties for the same cause of action in a court of any state or in the United States, and need not be dismissed on this ground, but may make such order as justice requires. And which 3 defenses can be raised at any time? 1, subject matter jurisdiction. 2, non-joinder. And 3, failure to state a cause of action. 154107, in a civil action, a judge shall be present at the examination of jurors when? And that would be on application of any party. So the judge does not have to be present at the examination of jurors, but on application of any party, he shall be present. 164111, a court has directed a jury to find a special verdict. In such case, the jury must determine what? That would be the facts only. A special verdict is the facts only. 173401, Who must provide full disclosure of all matter material and necessary in the prosecution of defense of an action, regardless of the burden of proof? So who must provide full disclosure? And that is 1, a party or an officer, director, member, agent, or employee of a party. 2, a person who possesses a cause of action or a defense. 3, a person about to depart the state or without the state or residing at a greater distance from the trial than 100 miles. 4, a person so sick not able to attend the trial. 5, person authorized to practice medical, dental, or podiatry who provided such to the party demanding the disclosure or was retained as an expert witness. And 6, any other person upon notice. 18, 3101. Materials that are generally discoverable. 1, a party's own statement. 2, contents of an insurance agreement. 3, accident reports. And 4, video and audio tapes of a party or employee of a party.